Today, let's talk about the case Gurrow versus ASIC as the Australian Securities and Investment Commission. At the beginning of the case, as the main actor, Ms. Gurrow has made a mistake as she made the offer without any information, including the prospectus and the lodgement to the ASIC as the requirements of the ASIC Act 2001. Therefore, she got the punishment of 7.5 in judgment of the industry and 80% of the 95% of the cost of ASIC. As the appeal again for that, and it is dismissed by the court, and the ASIC is therefore cross-court for that as well. However, the answer is dismissed as well because of the not support in the term as well. So how about the rules and duties there have for Ms. Gurrow? At the beginning of that, according to Section 727, she has to send the judgment lodgement to the ASIC at first before she made the offer. Otherwise, she will not eligible to make the offer. However, she did without that, which is wrong. Secondly, according to the Part 6 of the D2, she not only to do that, also she need to provide the information to the investors as well. However, she didn't do as well. Those sections are supported by the Section 21 of the Federal Court of Australia Act and the 1324 of the Corporation Act, which means she already breached the convention, whatever directly or indirectly, with the knowledge concerned. However, according to the Chapter 2 of the Criminal Code Act, she not only make the wrong in the Corporation Act, she also have made the criminal offense, as she's behavior already has the knowledge concerned, which defined as the directly or indirectly accessory liabilities. Therefore, she always breach of all of this contract.
Today, I will talk about the reason of the judgment about dismiss ASIC's appeal. Accessorial liability requires a real knowledge of the involvement in the essential element of the convention. For a claim in accessory liability to arise, it is necessary to show that the person was knowingly complicit in the commission of the offense as an intentional participant. The necessary intention is established if the person have a knowledge of the essential element of the convention. The knowledge must be willed and not constructed. This position was confirmed in ASIC. Amongst other allegations, Mr. Ronnie's Adelaide and Adelaide Corporation was alleged to be liable as a sorried under Section 79 of the AC 2001 in the alleged conventions by Mr. Roman Williams of the Section 181 to 182 of the AC 2001. The court states that the transaction was carried out as Mr. Adelaide initiated and with Mr. Williams' agreement and direction.
Hello everyone, my name is Dan. My student ID number is AEMS3005. Today I'm going to present impact of decision on the option of the company in Australia. Through this case, directors often use their own special status and arrest to seek foreign benefit. The specific way to prevent directors from abusing their power is usually to balance their power with obligation. That is, to strengthen the legal obligation and responsibility of the directors, and to encourage the director to normally or the promise of being bound by the obligation. In other words, director obligation can reduce the risk and fraud and mismanagement. Therefore, other companies should pay attention to this case. Judgment regulate director behavior, such like no brief and the misoperation of the company's property, no misoperation of the company funds or leading of company funds to others, no opening of account of the company's assets in its own name or in other name, no guarantee of the company's assets as guarantors for the company's shareholder or other personal debit obligation of competition and self-regulation, no obligation to disclose company security without promise.